Simonia, have we checked interpretation? Is it working?
Sorry.
I'm asking, have we done the check for interpretation?
They assigned themselves, so I'm sure it should work.
Okay, I'm gonna try. Maybe you speak. Let me switch the channel. Interpretation, is it working?
Oh, sorry. I'm also learning Zoom, so let me pause this.
It's working. I can hear you speaking in French on the French channel. Yeah. Yeah.
I think we should start 6 o'clock.
Good evening, participants. My name is, I've got a feedback. So let me just, okay. Good evening, participants. My name is Sibo Milendashe. Welcome to tonight's webinar to discuss the Convention on Ending Violence Against Women and Girls. We are at 6:01. Can we please give it until 6 people are still joining us? Apologies for the wait. Okay. Welcome, colleagues. My name is Sibongi Lendashe, and welcome to this conversation about the African Union Convention on Violence Against Women and Girls. This evening, I'm going to be joined by three speakers that we will introduce in due course. The most important thing to remember about tonight is that we have created the space as a learning space, because there are so many people who are really confused about the African Union Convention on Ending Violence Against Women and Girls. And it is very hard to be confused about a legal instrument, and we want to help share information about what is contained inside the convention. We do not take joy in providing this legal analysis, because when a new convention is passed, it is usually a moment of celebration. And so when that celebration turns into sadness because of what is contained inside, but on the other hand, there are still people who are joyful. As lawyers who use the legal instruments as our tools of trade, because we want them to create rights and binding legal obligations for state, there is a particular way in which we engage with the treaties and other people as well who do legal analysis on human rights treaties and have an understanding of how these legal instruments need to be written, the different sections for them to actually be fit for purpose. So today, together with Beijing Plus 30, we have decided to create this opportunity where we spend time with you to go through the convention. You'll be pleased to know that this controversial convention is actually quite short. Its full length is only 11 pages. So let me start. What we are going to do is to really talk about the type of things that we are seeing in this convention. First, we are saying that there were procedural gaps in how this convention was developed. I'll quickly go through that. That there are structural deficiencies in the convention. Then there are substantive gaps and operational flaws, and I will end with recommendations. People who have joined the webinar, please feel free to introduce yourself in the chat box. So in February of 2025, the African Convention adopted this, the African Union adopted this convention. At the moment, there is only one ratification. So this presentation is old. Last month, the Gambia became the first organization to ratify. There are 15 signatures that are required for this convention to enter force. The Article 4 that I'm going to mention sets out the objectives of the treaty. This is quite irregular, first of all, but we are mentioning it here because we want to start with why this treaty was developed. Article 4, objectives of the treaty, is what we call perambular content. In many documents, that's the preamble. Objectives are not found in the substantive section of a treaty, because the substantive section, which is the middle section of a treaty, contains the state obligations and the rights that we have as rights holders. So I am referring to this, but it's important for you because when we get to the structural section, I want you to understand what is structurally flawed about this, so that it's not just hyperbole when we are saying that this convention is shambolic. So Article 4 sets out the objectives of the treaty as to prescribe an enabling environment for ending violence against women by establishing and strengthening coordination mechanisms, providing preventive measures to end violence against women and girls, providing comprehensive support services, and to enhance enforcement mechanisms. This is important because normally when a treaty is developed, we normally have something called the treaty initiation process. So whoever it is that says we need to have a new treaty then provides the reasons. The reasons could be that maybe there are gaps that we have seen. It could be that there are emerging forms of violence that earlier treaties did not deal with adequately. And so it then sees a normative gap and then says, what we want to do with this new treaty, we want to build on that. These are the gaps that we want to close. But here we are sitting with an unusual problem that the way in which this convention was drafted, we don't even have a travail préparatoire, which is the preparatory works, which is often used as an interpretive aid when we are trying to ascertain the meaning of specific clauses or trying to understand what it is that the drafters were trying to do. We will go back to that. But because of how this convention was developed, we also don't have this. But be that as it may be, if we look at these things as the objectives of the treaty, then our analysis has to engage with whether these things that this treaty wanted to achieve, it has been able to achieve them. So the procedural gap that are in this convention, it's simply starting at the end. This convention was opened for ratification before it was publicly available to African citizens. So we first saw from the pages of the African Union Commission that Djibouti had signed. There were posts to that effect, and Djibouti was celebrated. And after a number of weeks, we learned that that was not a ratification because at the time, this had not been published. But this convention underwent post-adoption edits at the Office of the Legal Counsel. It was adopted in February of 2015 and only published in June of 2016 after these 4 months. The process of developing this convention was also not comprehensive, transparent, and consultative. The first draft of this convention appeared in September of 2024 at 156 pages and went through something that is also unusual, about 8 drafts. The 8 drafts are not unusual, but it was the way in which it was edited. It moved from 156 pages to 98 pages, from there to 48 pages, and it just kept on going down. And anyone who does any writing knows when you cut a document from 156 pages, you take it to 98, you take it to 48, you are essentially rewriting it. And by the 22nd of December, we were sitting with this convention ready for adoption in February. And on the 22nd of December, this convention had become 11 pages. So these are just like the timelines for the drafting. You can see September, October, November, December. And this contrasts with typical human rights treaty negotiations, which often span multiple years to allow for comprehensive consultation, deliberation, and refinement of legal text. Now let's move to the structural deficiencies in the convention. This convention is not drafted in consistency with treaty-making standards. Most of us who have seen treaties know that we have the preamble, the substantive provisions, and the operational provision. These conventions, like I've said, includes preambular content such as objectives and principles as part of the substantive provisions. While these objectives and principles may contain important considerations for preventing and responding to violence against women, they are not framed as legal normative standards, rights, or obligations, and so they lack binding legal effect. So if you see anything under Article 4 that talks about objectives and it talks about combating gender stereotypes, it is a legal nullity because there is no state obligation that has been created. There is no right that has been created. It's simply setting out what the convention intends to do. If it doesn't go ahead and do that in the convention, the objective is simply not met, but it doesn't mean that what it said it wanted to do, it would be able to do. Now, the thing that happens in this convention is that it has what we call fragmented normative standards. Normative standards are provided in these kind of fragmented components across various articles. And this makes it difficult to comprehensively identify the nature and scope of rights and obligations created by the convention. The implication of this is that legal clarity and enforceability is undermined. When we work on violence against women and girls, there are these standards that have been developed, these frameworks for responding to violence against women and girls that we have been talking about. We talk about these as customary, international law, things like due diligence obligations of the state to respond to violence against women. And what these due diligence obligations actually told us is that the state, if the state acts in such a way that perpetrators are not held accountable, then it is responsible for that violence. So whether the people who perpetrate violence, state actors, or they are people in the private sphere, right, in the private domain, the state's due diligence obligations are to investigate, prosecute, punish, offer remedies. So requires them to actually do this. We don't have this framework in the convention. You will find something that actually speaks about state obligations, but it is in this fragmented fashion. In 1992, one of the big things that happened in international law was the decisive link that was made between violence and discrimination. And that's why we have this language of gender-based violence, that this violence is overwhelmingly gender-specific because it disproportionately affects women more than men. And we are not saying that men or boys do not get violated, but we were talking about this violence as gendered. This framework is also absent, and the challenge of removing these established frameworks is that if you do not foreground like discrimination, then you start dealing with violence against women as any kind of crime or offense, which really removes all of these things that we had said we needed to develop so that the law is able to understand why normal criminal law, for instance, provisions are not able to protect women. Why women can go to court and then to the police and then go and withdraw, charges. Not because they don't want the perpetrators to be held accountable, but recognizing the complexities of this relationship, that sometimes all they want to do is for this violence to stop, not necessarily to send their partners to prison. So these are the things that have been removed in this convention. And so now you get all of these fragmented standards. In some provisions, there is an attempt, a consolidated approach to prevention and response, while in others, it adopts a sector-specific approach focusing on manifestations such as violence in the world of work. So you've got these due diligence standards that in one way, this convention could have just said, you know what, we're going to structure this convention and talk about the responsibility to protect, the responsibility to investigate, to prosecute, to punish, to offer remedies. So it struggles to hold this tension, whether it wants to be sector specific or it wants to actually be obligation specific. So then you find violence against women in the world of work, and then all the other worlds where women interface with violence are not present, in this convention. So these are some of the structural deficiencies. And Obviously, this makes it not aligned with existing standards because it doesn't build on CEDAW, it doesn't build on the Maputo Protocol, it does not build on the normative standards that have been developed by the African Human Rights Standards system, including the African Commission. So we say that the convention is also conceptually weak in that it features narrow and limited definitions that are often not operationalized through substantive provisions, creating the requisite normative legal standards. It mentions family, it defines family, but there is no family anywhere in the substantive provisions of the convention. But the conceptual narrowness or contextual blindness and internal consistency are some of the things that we see here. So, for example, there is something about cyberspace. So when they are talking about cyberspace, that's one of the biggest innovations. Yes, it's a new thing that has happening. It's an emerging form of violence, but there is a reason why we're not talking about cyberspace violence. We are talking about technology-facilitated violence, because what we want to surface here is the way in which technology is used now to facilitate violence. So that it happens in the cyberspace, it's one thing, but we also know that that is not the key thing, because this violence quickly moves from online to offline. So the problem is not that it happens in the cyberspace, it's that technology is used to do all of these things. But the conceptual narrowness is that it only sees cyberspace as a sphere where harm can take place, but it fails to actually create obligations that says, what do we need to do with this tech-facilitated gender-based violence? And there are standards that have been developed, soft laws, that this convention could have concretized now into binding legal obligations. We know that we need to criminalize all these emerging forms of violence, because sometimes they say, but that is not a crime in this country. Things like upskirting, someone putting a phone under women's skirts and taking pictures of them, right? We have seen doxing. We have seen this AI undressing people. Like, all of these things that are happening in technology, you prohibit this. That's what it means as a state obligation. You deal with big tech because they have to regulate these platforms. You have to regulate harmful content. You have to deal with cross-border, kind of jurisdiction and all of that, because some of these things do not happen here. This convention is silent on all of these things. Now, for a convention that's supposed to respond to violence in Africa, there are serious critical omissions. FGM is not mentioned. Child marriage is not mentioned. Conflict-related sexual violence is not mentioned in this convention. So CVOG is sometimes a regression from existing human rights standards. So here I'm going to quickly go through the substantive definitions. Cyberspace includes cyberspace instead of comprehensively addressing this tech-facilitated GBV, which is seen as a zone rather than as an emerging form of violence, and there are no normative standards. The second definition that is very regressive is women human rights defenders. Women human rights defenders are defined on the basis of nationality, meaning that non-nationals are excluded. So people like me who run around this continent will not have protections as a human rights defender because I am protected as a human rights defender in South Africa. On a continent that is built on transnational solidarity, one can actually see how this is a regression. But it's also gender discrimination, because if we didn't have this convention, we would not have our rights limited in this way. And men, on the other hand, who don't have a convention like this, continue to have the acceptable definition as human rights defenders because they don't have this women human rights defenders narrow definition. Harmful practices, they fail to mention FGM. Femicide only appears haphazardly as an add-on, always framed as including femicide, without the requisite state obligations for responding to femicide. It defines femicide without locating it within this broader established framework of gender-related killings. It goes on to give us something like positive masculinity and African values. These are concepts with no legal clarity or legal substance within the convention. So it leaves the interpretation of underspecified concepts largely to the discretion of states. Family is also regressive. It departs from legal developments that challenge the patriarchal and exclusionary assumption of this historically embedded concept. It leaves the definition and provision of family to states. Yes, there has been a push. We haven't tried to define what a family is because there is a recognition that families are evolving and they come in all shapes and sizes. So what we focus on is the protection of people in families. This convention agrees that member states can define what a family is, but it introduces something else. It says member states, family is as provided for by member states, which is not what treaties usually do, because this is not a definition only anymore. It tells you that family is whatever it is that a member state provides for. So if a member state actually allows for discrimination, then this convention says a member state has provided in that way. In this continent, the Gambia, for instance, is the only country that retains what people fought for in the 80s, in the 90s, against the removal of clawback clauses from those constitutions that we inherited from the British when we gained independence. Those that said, yes, everyone has got the right to equality, but equality does not apply in personal laws or family laws. This convention says whatever it is that the member state provide for, that's the definition of family. And this is a removal of family from the protection under international law. So this convention has several definitions and terms that feature in the definition section but do not appear in the text, and also terms that feature in the text that do not feature in the definition section. When you look at things like family, it simply tells you that the intention here was to define family for the purposes of removing it from the protection of international law. So this convention doesn't even deal with something like domestic violence, because why would it do that? Because family is as provided for by member states. So there's also weak normative grounding in this convention. This convention fails to ground the right to be free from violence in the right to non-discrimination. And I mentioned this in the beginning, but Maputo Protocol does this, but this does not. State obligations. So when we go back to the question of the definition, Article 2 tells us that everyone has the right to be free from violence. That's the only right. But we know that in Constitution, and also we've tried to define this right to include in public or private, in order to make the emphasis that women and girls are protected from violence in the private sphere. This is not part of the definition. This issue of public and private sphere is then moved to Article 3, which tries to define the scope of the convention. It then says this convention applies in the public, private sphere, and cyberspace. And the problem with this is that cyberspace is not just a sphere, and cyberspace is both public and private, right? So now you are introducing a confusion about what it is that we are trying to do when we define violence, freedom from violence in both of these spheres. So this is an unnecessary way of kind of splitting the definition of freedom from violence, which we have fought for to include as part of the definition, like protection from violence in both of these spheres. There is a lack of precision necessary to generate enforceable obligations on domestic law. And there's a lack of normative coherence between CVOG and existing instruments like Maputo Protocol and CEDAW. And here, what we are seeing is a risk of fragmentation of the African gender justice regime. And this is concerning because we are in the middle of a fight where we are actually seeing an attempt to rewrite what human rights standards are by anti-rights actors. So we call this norm entrepreneurship, where people are actually going around selling new norms in different kind of processes that are developing standards. So we don't see this as just like carelessness or lack of intentionality, because some of us have been following conversation around this draft charter on family values. The family values actually is foregrounded conversation on this issue of state sovereignty, that the state is sovereign and then sovereignty is then used to remove accountability. So when you see how women human rights defenders are defined, when you see how families are defined, then you begin to see this version, this convention acting as a gateway to the African Convention. So when we go through, I have mentioned Article 2, which is a definition, Article 3, which is the scope, Article 4, which are the objectives which are not supposed to be there, Article 5, which tries to set out state obligation, but also fails because it does not capture, it just fragments and has got like subsets of those things. Article 6 has got principles. Principles do not create binding obligations, and therefore they are like a legal nullity. You go to Article 7, you find something that attempts to deal with intersecting form of violence, but it actually does not use the language of intersectionality because they say that member states do not like it. But even if one was trying to say that the existence of different intersecting forms of violence or oppressions exacerbates the violence that people have, they have a lot of grounds that they mention there, including something called health-related shocks. But there is not one intersecting form of violence that is actually given attention. So they mention elderly women, but they do not talk about the state obligations, to help them, to protect them from violence that's based on age, and gender. Or they talk about women with disabilities, but the obligations of what states need to do is absent, in the same way that they talk about, this is all Article 7, conflict-related sexual violence. They don't actually name it like that, but you can see what they are trying to talk about in conflict. So the state obligations under Article 7, but it's not even created as a binding obligation. They are saying the state must take cognizance. So, which also makes Article 7 some kind of a legal nullity. It continues like that. It moves on to the rights of women in the protection of women in the world of work, and fails to mention things like sexual harassment. And then it talks about girls in the world of work. This is the only substantive provision that is dedicated to girls in this convention, that these girls are not at school, these girls are not enforced marriages or subjected to FGM, but what has been prioritized is girls in the world of work. Finally, I want to get to these operational flaws, quickly, that the implementation of this framework has been given to the African Commission. There are a number of campaigns at the African Commission around its powers to implement and monitor, the African Charter itself. And there is a very unusual thing that was contained in the African Charter about confidentiality. What it means is that there is this interpretation that if you file a case before the African Commission, it is confidential until the decision is adopted by member states. So there is no cause list. If you go to the website of the African Commission, you will never get a list of cases that are pending. You are not supposed to tell people you have filed a case. There is a friend of the court provision, amicus curiae, but you cannot intervene as amicus curiae because you're going to say you had, how did you find out about this case that is actually confidential? So there has been campaigns there that says this is actually a barrier of access to justice, transparency of the judicial process, and all of those things. So to take a new convention and put it in a mechanism that has got these serious design flaws, the African Court does not have this limitation. The African Committee on the Rights of the Child does not have these comparable accountability mechanisms, do not have this. So what we are really dealing with here is something that was flawed, that we have not been able to actually resolve in over 4 years of the African Commission. And that's why we are worried about people who are saying that we should do this in this way. I am going to hand over to Dr. Ruth Nekura, who is a legal scholar, a lawyer, and a member of the ISLA panel of experts, to actually talk to us, to give us her comments regarding what has actually been happening and some of the distortions that we are seeing regarding this convention. Over to you, Ruth. Thank you.
Thank you so much, Spongile. Thank you so much, everyone, for joining. And I think the first thing I just want to say is, listening to Spongile now, it sounds very eloquent, the analysis of this convention, but it hasn't always been easy to analyze this convention, actually. It was very difficult. And some part of the reason why is that when you bring a legal lens to a convention, there's an expectation at the back of your mind as a lawyer, that you will see certain things that are typically expected to be in a convention, and that's what you will analyze. So as we'll see, that is not what we are dealing with here. We are dealing with a fragmented, structurally flawed, substantively flawed, and also flawed in terms of process, which explains why it is what it is. So I'll speak briefly about dispelling some myths, because there is a lot within the legal analysis, but what we were trying to do when we developed the legal analysis is to provide clarity, because there's just a lot of confusion. And I want to address some of the myths and the confusion that is existing in the space about this convention. But before I do that, I just want to start by saying we need to name this for what it is. This is a convention. And in order for us to understand some of its gaps and challenges, it's important to sort of restate what is a treaty, what's the purpose of a treaty, what is it actually supposed to do. It's not a program document, it's not a donor report, it's not even a policy, it's not a statute, it's not a national law. So what is a convention? What's a treaty? Then we can understand why it's weak. A treaty is an agreement between states, right? We know that. And it's a legal instrument that should outline very specific obligations for states. It should set out very clear normative standards and an enforcement mechanism for those standards. And this is because many of us, I'm sure, have been in spaces where we've talked about the gap, the implementation gap. You can have a very good law on paper, but that does not translate to anything in practice. So in order for the treaty to actually mean something in practice, we need an enforcement mechanism. Now, a treaty has a purpose, and the purpose of a human rights treaty, and the AU is very good with this, if you look at other AU conventions, is to address very specific human rights concerns and issues, to provide very substantive rights related to this issue, and to create very clear state obligations so that states actually know what to do related to those rights that have been created, and to create normative standards that actually work towards addressing the specific human rights that we are talking about. So it should be clear what the law is. And then to ensure that these legal norms and standards or the law actually have an effect of respecting, protecting, promoting, fulfilling the rights in that specific framework. So for a few minutes, I'll go into some myths that have been circulating around this convention. And the first one is that, this is the first time that we have in Africa state obligations on violence against women created in a convention on ending violence against women. And this is just a flat out lie. It's false because we know that before this convention, we already had the African Charter, we had the Maputo Protocol, which is a protocol to the African Charter, and already the protocol provided very comprehensive rights on violence against women. Article 4, for example, specifically deals with state obligations to address violence against women. And if you look at Article 4, and you look at the rights that are created there and the state obligations, it's a really good article. And I can share in the chat later an open access article that I did. The Center for Human Rights did a commentary on the Maputo Protocol to say what is the scope, the nature of every right there. And when you look at the commentary on Article 4, you will actually be proud of the Maputo Protocol, in terms of that regard. So we didn't actually have a normative gap, and that's not the only standard that exists. At Maputo Protocol already has provisions on eliminating harmful practices, which are missing here. There were very clear state obligations around sexual, verbal, and all other forms of violence against women and girls, Article 3, Article 4.2, on trafficking against women, on child marriage, Article 6, access to justice, Article 8. I could go on and on. But I will share this with you so that you can know. There was a question about, in Africa, do we even need a convention on ending violence against women? And when President Ramaphosa first proposed this idea in 2019, many of us were actually excited because we thought it meant that we would move the normative standards even further than what we already have. But it's not that we were starting from scratch. There was already really strong normative standards that existed on the continent. Second is, you've heard that this is a legally binding instrument with binding standards on violence against women. And as we've just heard from Sibongile now, what is being referred to as binding standards on violence against women mainly sit within Article 4 and 6, which are preambular. They are not legal, they don't create legal standards. Article 4 is objectives. If you look at the convention, objectives of the convention typically is not even something that falls within a convention because it's the intention that people had, when they said, let's draft this convention. The objectives remained as they are. I work as a consultant. So normally when you get terms of reference to do something, say if I was going to develop this convention, I would get TORs that will say, we would like a convention that does this, 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 and this. Those are the objectives of the consultancy. If we now copy-pasted those objectives into a convention and call that normative standards, it's slightly insulting, right? Because the goal was to actually do the thing, not to copy-paste the objectives of what you intend to do. So it does not actually create the standards, but I suppose if you're reading it without a legal eye, you can see very good words in there. They sound like the things we do when we do the work of challenging, gender-based violence on the continent. You'll see the buzzwords, but legally they mean nothing because no legal standards are actually created. They are written as objectives or principles. These are intentions. The thing itself is not done. The other one I want to address is people have said that this is a standalone convention and that and I'll address two myths at the same time here, right? People have said this is a standalone convention, which then should make it stronger than the Maputo Protocol, because the Maputo Protocol is simply a protocol to the African Charter on Human and People's Rights. Now, if you understand human rights law, you will know that actually it doesn't matter so much whether something is a convention, standalone, or a protocol to a convention. Both of those are treaties. And by treaties, they are, like we said, agreements between states for which member states have to ratify in order for those normative standards to bind them. So the Maputo Protocol is in equal standing as this convention because it is also a separate treaty for which states actually have to ratify. So that is a lie, If what matters at the end of the day is not that something is a standalone convention, what matters is the normative standards within that treaty That's what matters. Are they weak or are they strong? So, of course, it's very good to have a standalone convention on violence against women. Why? Because it provides a lot more room to substantively go deeper into a provision that within the Maputo Protocol would be one single provision or 3 separate provisions read together. A convention provides that opportunity. So if you look at the Council of Europe or the Inter-American Human Rights System, they do have a standalone convention on violence against women, and they are amazing, right? They go deeper, they go wider. You can articulate a lot more normative standards, but that's not what happened here. And the second myth related to that is that it's a standalone instrument, and therefore, because it's standalone, we just should not challenge it because it really provides for us an opportunity. This is the first time in the continent that we've really addressed violence against women in a serious way. But as we've seen, that's actually not true. So it's a myth that we need to dispel. The next one is that we've heard a lot in webinars that probably you've attended that this convention is a result of a lot of women's rights advocacy, decades where women's rights groups, have come together and contributed towards the development of this convention. This again is false. And there are 2 articles that I will share to evidence this. One is there's an article by Dr. Mariam Kamunyu, who's also a member of ISLA's panel of experts, which is actually called I Object, where she outlines in detail the participatory flaws of the process of developing this convention. The second one I'll upload is a survey. We did an analysis of it's in our FAQs, but you will see the write-up where we document how we did a survey of about 1,500 people within the sector who attended our conversations. And what we found is that less than I think 30% were actually said they were even aware that a convention is coming. And of the few that actually were involved, many of them were very much, their points were not being taken in. It's sort of like they were being brought on to just ratify a process and rubber stamp a process that was already going on. A lot of feedback that was given was not taken into account. There was an online platform by NEPAD that was open for about 3 months where people could go and share initially what thoughts you would want for an African convention. But after that survey closed, people don't know what happened to their feedback. The draft of the convention itself was never circulated. In fact, for those of us who know people who are in the committee, because of the work we do, we would receive secret drafts passed through WhatsApp, kind of shared in that way. And yet a convention should not be a surprise. It's a law for the entire continent, Women and girls and gender diverse people should be involved in a convention on gender-based violence. It should be in the same way we saw, for instance, with the Maputo Protocol. This is not a secret. People should have opportunity to actually comment. So it is not true that it was a product of women's rights advocacy groups or anything like that. And in fact, we need to talk a bit sometime maybe later about positive masculinity, because that was the framing that led to this convention. And we need to talk about what that means, whether positive masculinity frameworks or processes are actually accountable to the gender justice vision, to the ecosystem, feminist ecosystem, because those are actually the people, the African women and girls that should be leading this issue. All right. I'm almost stopping, but you can please feel free to interrupt me if I go on for too long. Another myth I would like to dispel is that that people have said a lot that, okay, it's a weak convention, but why don't we, if we read it with the Maputo Protocol, it complements the existing normative standards, right? Like we will read them together. And this is a problematic narrative because, as we've just heard from Sibongile's presentation, this convention does not complement the Maputo Protocol. It does not even complement the African Union's own standards. The Niamey guidelines, for example, that were produced by the African Commission are really deep, substantively meaningful, and they are about sexual violence. So I actually have been wondering why the Niamey standards were not used as a basis for this convention, because the Niamey guidelines move further from the Maputo Protocol in terms of articulating state obligations and rights. Now, why not take this opportunity to concretize that soft law into a convention and then expand it beyond sexual violence? So on the continent, we are brilliant. We have we have really good standards and frameworks. So it's very surprising to see a convention that takes us eons back from what already exists on the continent, and also then the other international standards that many African countries have already ratified at the UN level, for example. The convention is directly contradictory and weak in comparison to the UN global standards on violence against women, especially the general recommendations that have come from the CEDAW committee. I mean, it is very shocking that in this day and age, we would end up with something that weakens what already exists. When we had this conversation with the Kenyan member states, one of the things that was shocking in the room is when people would say, actually, if Kenya ratified this convention, it would weaken Kenya's own standards. So the convention is weaker than many African countries' own standards on violence against women and girls. So it's surprising to say that we will read it in complementarity with existing law, when in fact reading it in complementarity would weaken the entire legal normative standards that we have. So what does this all mean? You know, I want us to say to ourselves, what does this mean? Because we have seen the gaps in process, we've seen the gaps in structure, in substance. What it means in simple terms is basically that it is not implementable. This convention as is not implementable. States will not know the scope and nature of their obligations. Implementation, which is already a difficult thing, as many of us will know, because of lack of political will or limited resources, will now be impossible because even the normative standards to implement themselves do not exist. And the example of cyberspace is an interesting one, because if you create a legal standard language within a convention and say cyberspace, when in fact you're trying to address technology-facilitated gender-based violence, what Sibongile is saying is this is a cyberspace is a zone, is a space. It's like saying the living room or the dining room. But what about the living room? Yes, domestic violence can happen in the living room, but you actually have to create standards for domestic violence as it happens in different spaces, including the living room, the cyberspace there, and all of that. So we have a convention that's a regression from existing state obligations on violence against women on the continent, nationally, internationally. We have a convention that lacks protection and accountability framework. And because it fails to create these standards on gender-based violence and discrimination, and actually fails to anchor that within the root causes of violence, which we know is gender-based discrimination, it actually makes it unimplementable in reality. The other thing that is a bit disappointing is that it's actually not responsive to context. We expected that if we were going to have a convention, an African convention on violence against women, it would respond to the actual lived realities of women and girls on the continent. It does not do that. And the obvious examples that Sibongile has given, you can't have a convention on violence in Africa and not talk about FGM or child marriage or conflict-related violence. So that makes it actually unimplementable. The things we need to protect African women and girls from are not there. So can anything be done? And I think this has been the question for many people. Are we now hopeless, because we are sitting here with a convention that is weak, and many people are saying, let's just move on with it because it's already been adopted. But actually, that's not true. We know that African Union treaties can be revised and can be strengthened before they enter into force. And in fact, at the moment, we have a window of opportunity. The AU does have precedent of withdrawing treaties that have been adopted, strengthening them, and then bringing them back for the process of ratification. And there are 3 examples, and I won't go into them because we'll share this document in the chat. The Protocol on the Court of Justice to the African Union in 2003, the African Conservation Treaty, the African Maritime Transport Charter. All of these are examples of moments where there was, okay, pause, wait. Maybe we didn't actually end up with what we wanted. Let's pause, let's take a step back to strengthen, and then let's come back and work with something that's fit for purpose. So what we know is that it is possible to actually make a difference in this. And there is very clear processes, which maybe we can talk about later about at the call to action about how to go about doing this. But I will close with a comparative example, a little story about how this has happened in other parts of the world. In 2014, the Istanbul Convention, which is the Council of Europe's Convention on Ending Violence Against Women, the standalone convention, entered into force. And this convention opened up for signing, I think, in 2011, which was 2 years after a very landmark case, which was Opus versus Turkey. So it's called Istanbul Convention because, it carries the name of Istanbul, actually, like Turkey. And 2 years before that, the European Court of Human Rights issued a very landmark decision on protection of women from domestic violence in Opus versus Turkey. And there's a direct correlation between feminist advocacy following the Opus versus Turkey decision and how that fed into the process of developing a regional convention on ending violence against women and girls that actually resulted in the Istanbul Convention, which, if you read it, has very solid standards. So we know from other contexts that processes can be different, they can be better, and they do lead to something that's more meaningful. And the second example is the Inter-American Human Rights System, the Belém do Pará, which is an earlier convention in 1994. And this one is 2014, the Istanbul. Our convention is 2025. We had all the opportunity to not just learn from the jurisprudence that exists and the soft law, including of our own Pan-African context, to make something stronger. So my last word really here is, I feel like it's time for all of us in this moment to stand up and be counted as people who will stand up for actually defending the normative standards that we already have. Because I came to this work about 15 years ago, and before that, we always hear stories of people who were there when the Maputo Protocol was being developed and how there was pushback and all of that. And up to today, we are benefiting from the legacies of people who pushed for a normative framework. It's not perfect. The Maputo Protocol is not perfect. And nobody has been saying we want a perfect convention. But you can clearly see a solid instrument that came as a result of intentional feminist organizing, but also just multiple stakeholders being involved. And you can trace that back through the Travaux Préparatoires. You can see the story and how it was written. And I feel like this is our time, for us to say whether we want to be the generation that allowed a convention like this to stand, because they will say, in the times of, like this, it is us that were here. So what are we going to do in order to make sure that the legacy we leave for the future generation is actually meaningful and something that's possible of capable of implementation to actually end violence against women and girls? I'm sorry for taking long, but I will stop there.
Thank you so much, Ruth, for that master class on debunking these distortions of this thing being something that's kind of good for us and putting us in this position that trying to make us believe that nothing can be done and that this is the best that we could have gotten from the process, and also helping to chart that went forward. I'd like us now to go to Tlamelo Mutudi, who is with FAB in Botswana, the Feminist Alliance of Botswana. Please, Tlamelo, let us hear what you have been doing in Botswana to resist this, because we need to hear those words of hope. Thank you. Over to you, Tlamelo.
Okay, good evening. Thank you so much for having me. My apologies for my inability to put on my my camera. So please do bear with me. Greetings from cold Gaborone, Botswana. Mine today, and before I even start, it's actually been quite interesting hearing from the first and second speaker, because we resonate so much with a lot of what has been spoken about with regards to the gaps that have been identified. In Botswana specifically, and maybe let me start by saying that one of the things that concerned us is that Botswana is a dual estate. So unlike other jurisdictions where ratification would then result in automatic application at a national level. It's not like that in Botswana. So in Botswana, for after ratification happens, then we would need to, through an act of parliament, then make it applicable at a national level. So it's quite shocking to hear speakers talk about discussions around the convention that started in September 2024. And more so because when we came into the picture about consultations around the African Union Convention and finding out about it, it was about a day before the first consultation, which happened on the 1st of April. And it was the first time we actually heard that there was this convention that Botswana was seeking to ratify. So we were caught by surprise. Nonetheless, through support by Force Feminista, we were able to mobilize as Feminist Alliance Botswana, and we then attended the first consultation that happened during the 1st of April. Now, before I go on and just unpack what consultations look like at a national level, I must say that for me, and I think for me as a woman, as a mother, as a daughter, as someone's aunt, when we talk about consultation and participation in issues that are important to us, that involve us, that impact us, it's important that the participation happens in a particular kind of way. So one of the things that we raised was how the participation was happening at a national level, because unlike South Africa, for example, Botswana doesn't have the rights to participate and consultation embedded in our constitution. So when it happens at a national level, we are often frustrated because we feel like it happens with a tick box. And for me, meaningful participation, I align with the International Association for Public Participation, which stipulates that public participation must inform people. So we must have information about what we are being asked to weigh in on. We must be consulted, and we must be consulted to get our views, to get our analysis, and to get what alternatives we're putting forward. We must also be involved, and we must be involved throughout the process in a meaningful way, in a way that makes sense. And we must be collaborators and decision makers in a way that we are going to be empowered, because we will then, our decisions will be the ones that are put forward. So while I unpack what consultation and public participation look like for us in Botswana, please can you keep these elements of what participation should look like in mind? So we attended the first consultation that happened on the 1st of April, and then it was just to inform us that Botswana intends to ratify the African Convention. Now, we had about, like I said, a day to look through the convention and to cross-reference it with SADC model law on gender-based violence, with the African Charter, with Maputo. We even looked at Belém, we looked far and wide to really get an idea of what is it that this convention should look like, how is it lacking, and how can we put forward our arguments about why it is that Botswana should not ratify. During the 1st of April consultation, we made it very clear that there's a lack of civil society presence in the room. And that for us was quite concerning. And I think it's also reflective in how it is that the convention is written. Some of the issues have been raised. For example, the fact that the definition of family has been left to stays to the side, even in environments where we can see anti-rights, even states are pushing anti-rights mandates. Another thing is, for example, the representation of children. And for us, it was quite important because in Botswana, we have a National Children's Council. And we thought, why is the council not in the room? Other representation was queer voices, disabled voices in the room. So we questioned if there were enough civil society and women presence in the room for us to make this decision and for us to be able to make it in an informed way. We were then given an opportunity to give a written response, which we were given until the 8th of May to do. So from the 1st of April, Feminist Alliance Botswana then started mobilizing, and just in the civil society spaces and with the partners we work with. And from that mobilization, and I think this also talks about intentionality sometimes, from the mobilization, and we did this mobilization online alone, we were able to gather 24 civil society organizations and 26 women to then endorse the civil society response that we presented to the Ministry of Youth and Gender Affairs. Pardon me, I didn't mention that the Ministry of Youth and Gender Affairs is a ministry responsible for conducting the public participation and consultation processes in Botswana thus far. So on the 8th of May, we were given an opportunity to then present our civil society paper. And even then we raised concern because before the 8th of May, we were not given a lot of detail about what would happen on the 8th of May once we presented. Nonetheless, we put together the response and we went to present. We were then met with I think the previous speaker talked about myths, about why it is that Botswana should ratify the convention. And some of the response that we got was that it's important for Botswana to ratify the convention because it will put us in the room, right? And once we're in the room, then we can talk about the weaknesses of the convention. So it wasn't that the convention was not considered weak, no. There was acknowledgement even from the ministry itself and from other players in the room, some of which were ambassadors, etc. And they themselves said, yes, the convention is weak, but let us ratify and then let us then deal with these weaknesses and call for amendments. Now, as a civil society, we were quite taken back because we know what amendments look like at a national level, never mind at an international level with this kind of a treaty in place. From then, there was another engagement which took place on the 4th of June, but we only found out about the consultation on the 4th of June, on the 2nd of June. And even then, we did not know what would happen during the third round of consultations. When we arrived for the third round of consultations, we then found that we were getting a response to the civil society response to Botswana's ratification. But the response wasn't written. It was just to gather civil society organizations. And part of the gathering we were responsible for because we were asked to kindly go and call all the civil society organizations that had endorsed the statement. So we were quite taken aback and again put forward our reservations to say, we were not given an opportunity to then respond to the responses that came from the Ministry of Youth and Gender about why it is Botswana should go ahead nonetheless. The final consultation happened recently on the 16th of July. And that consultation happened where representatives from the African Union were in Botswana at that time. And so they met with us. Again, we only found out a few days before the 16th of July consultation. And again, we did not know what it would entail. We only found out when we got there that actually the African Union representatives had been given our response and that they then responded to it, but, just very, very, in a very limited, I think, context was their response. So what we have come to realize, and sadly so, is that this consultation process where civil society organizations were asked to come, and even when we did come, one of the things we raised was that it's difficult for us to even put forward a civil society response paper because we are acknowledging in the paper that because of the limited amount of time that we had to really mobilize, and part of mobilizing is also equipping other civil society actors and women in Botswana with information about this African Union Convention and what ratification would mean and why we think that there are gaps, whether substantive gaps, whether they're weak normative grounding, whether operational gaps themselves. So we really battled with the resources to be able to mobilize as much as we wanted to, but we said we'll do our best. So we found that it seems that Botswana is intending to ratify the convention, which is quite shocking to us, considering that the consultation has been more of a tick box than anything. And one of the things that we raised, Mayor Ndashe, when she spoke earlier on about some of the flaws in the definition and the body of the convention itself, we echo with those. We also raised the fact that, when you talk about women and girls, there's no mention of transgender, non-binary, genderqueer persons. When we talk about, human rights defenders, we are excluding women that ordinarily are not at the center of discussions and conversations around violence. And those are refugee women, stateless women, migrant women. And most importantly, that we're excluding the conversation and the voices of children. One thing that we continue to ask is, it's already difficult for children to be able to report in cases of any kind of violence, because they don't have as much movement as we do. They don't have as much access to financial resources than we do. So how do the voices of children, how are they highlighted in a convention like this, especially when it comes to reporting for children? So another thing that we have been putting forward as Feminist Alliance Botswana is that we have been struggling in country to domesticate the Maputo Protocol. Our constitutional has been undergoing various amendments. There was one amendment in 2024, and then another amendment which was supposed to take place, which again has caused concern nationally, because we have found that the amendments that they seek to do to the constitution are not giving women in Botswana more rights than they already have. For example, in Botswana, we don't have socioeconomic rights. So in 2024 was the first time that the right to health was included in our constitution. We don't have environmental rights in our constitution. We don't have health rights as mentioned. And in 2024, for the first time, intersex was put as a ground upon which discrimination is prohibited. So when we were in consultation with the Ministry of Youth and Gender Affairs, we said to them that we are of the opinion that the convention is not fit for purpose. It's not strong enough. It does not in any way fill the gaps that might be apparent from, the Maputo Protocol. It does not in any way, stand beside and help to complement the Maputo Protocol. And one thing we questioned was, how, if we're struggling to domesticate Maputo Protocol, are we rushing to ratify the African Union Convention, which is actually weaker than the Maputo Protocol is? How are we rushing to ratify the African Union Convention when our constitution itself fails to give women socioeconomic rights? Should we not rather strengthen our constitutional framework, pause before ratification, deal with the amendments that have been put forward and strengthening that's been put forward that we need to do by the civil society organizations that you brought together to get a response from? And then once we are satisfied that in a world where we are losing rights, that we have ensured that we have strengthened as much rights as we can for women and girls, and we are satisfied with what that looks like, then we can ratify, and then from ratification, then domesticate. So from the last, and it's quite unfortunate, from the last engagement we had, and it also talks to the fact that, a lot of these conversations are being had and a platform is being created by institutions that have the resources, and they're calling on civil society organizations to come and interact with them. And outside of that platform, those platforms, when we are called to come and consult with Ministry of Youth and Gender Affairs, or when we called to consult with the African Union, the amount of time that we have to consult is also limited, which means that we cannot actually have a conversation about, why it is that we should not ratify. I think at any given time, all of those 4 consultations we had about an hour, 30 minutes at the most, pushing to 2 hours, which is never enough time to talk about something of grave concern as this African Union Convention. So going forward, one of the things that we are struggling with is to how do we educate? Because even during the consultation that was held by the Ministry of Youth and Gender Affairs, what we picked up is that there's not a good understanding of the convention itself amongst Botswana women, amongst Botswana CSOs. There's not a good understanding of how the convention came to be. There's not a good understanding of some of the gaps that we have picked up and we've been able to pick up on. Because the unfortunate thing, and I think it's something that we must all go through as civil society, is that we are based here in the capital city, Gaborone. The consultations were happening in Gaborone. Granted, they were online, so people outside of Gaborone could also connect. But when the consultation started, the convention itself was not even given ahead of the consultation. So it wasn't something that we had readily available to us. We had to go and source. And the convention is in English, and this is something that we struggle with internally with regards to consultations around any kinds of law and policies, is that it's in language that when you go outside to the outskirts of Botswana, English doesn't become a language that's most often spoken. So by making the convention available in a language that Botswana may not understand, you're already ensuring that you are limiting the participation of quite a lot of women and children within the country as it is. So I liked the question that was then asked, where to from here? And what is our responsibility collectively as women throughout Africa? Because this is supposed to be something that's supposed to protect us and that we're supposed to be able to see ourselves in. The convention fails to even name a quarter of the kinds of violence that women experience. We are seeing that violence against women is evolving. We talked about technology-facilitated gender-based violence and how that's evolving from online to offline, but it even fails to properly capture what that looks like. So what does that mean for us here? Do we just give up and say, okay, our countries are not interested in consulting us, or do we continue to push? Another myth that I've been hearing in these consultations, and unfortunately this myth is also coming from civil society actors because of that lack of information and education around the convention and how strong the convention could possibly be, is that failing to ratify this convention would mean that we are stepping back with regards to the rights of women. And that for me, I think is the one myth that truly, truly, truly hurts me, is that we are actually not, by ratifying the convention, that is how we are stepping back. And we are not using this opportunity. And mind you, one of the comments has also been that, this convention has been argued between member states for a long time. And I sat and thought to myself, out of the 54 heads of states, only 52 or only 2 are women, while 52 are men. So these men, 52 men, sat and they discussed what our rights look like, what responding to violence against us looks like. And now, and what is even more upsetting for me is that the people that are going to call for the ratification of the African Union Convention are women and girls, well, women like us, that are saying we should ratify and then later work towards strengthening it. And as mentioned by our myth buster, Ruth, there have been instances where conventions in the past have been paused, strengthened, and then ratified. So there's no reason why this convention can't be paused, strengthened, and then ratified. And for countries where domestication of other conventions like Maputo, and countries where the constitutional mechanisms of those countries are weak, it will also give us an opportunity to strengthen, so that by the time that we ratify and then domesticate something as important as this convention, then it is fit for purpose. Thank you.
Thank you, Pamela. Our next speaker, Ambassador Bridget Mabandla, is going to help us answer some of the questions that Lamelo has raised, because when we spoke earlier today, she said she didn't want to come in as a lawyer. She wanted to come in as an elder. And as an elder, those questions we ask them sometimes and tell us, what do we do kind of going forward? I do know that for people who are in Johannesburg on Saturday, we're going to take African citizens to the African Union to have a little conversation outside the picket line. But Bridget, Ambassador Bridget Mabandla, please come in and sum it up for us, what you think the way forward in this difficult conversation should be. We don't want to be an opposition. We are simply asking for stronger legal standards. That's what Tamelo was saying, and the fight that we are hearing about that's been going on in Botswana to try and push back in that difficult context. Over to you, Ambassador.
Bongile. Thank you very much to the panel. So far, brilliant inputs, informative, educational, and inspiring, I must say. You know, I was thinking, what is it that I can say that will be of use? You know, I think the first thing for me to share with you is that, in fact, the African Charter on Human and People's Rights was a hard-won victory for the progressives at the time. I recall many years, that is long, many years before 1981, when it was adopted, the Charter, that there were very difficult debates in the OAU. At the time, I was a young woman and I was a delegate. My observation was that against odds, Africa did find consensus around very difficult issues such as religion and culture. I don't think we want to lose that. And the other thing that I thought I should share with you is that, you know, non-state actors, progressive non-governmental organizations can actually and have succeeded in bringing about great change on this, you know. For example, I'm just thinking here that just using the example of the celebration of the United Nations Charter 50th anniversary, that in fact non-governmental organizations took the opportunity to critique the charter then and to network internationally, South-South, and even developing countries involved, NGOs, non-government platforms at universities actually opened up and participated in scholarly research around elements of the charter and came out with much deeper definitions and also eventually programs around peace, development, equality, and justice. And I think that at that time, they actually influenced eventual improvements even in CEDAW, you know. So I think that this movement now, these programs that we have started, the discussions, nothing beats extensive debates and discussions across a state, so including state and NGOs. So I think you are on the right course by saying you are opening up this. You are going to continue to engage around this supposed convention. We cannot lose the gains that we have had. We cannot reverse what is in the Maputo protocol, surely. So mine is to say thank you very much for inviting me. And yeah, I think it's time to really get down to hard work and engage. Beijing plus 30. I'm sure that we are in it. We need to reach out to states, guys. We need to talk to governments. I don't know if we can do that through AU entities like the PEP, but let's try. Thank you. That's all I can say for now. But thank you very much for great critique and information.
Thank you, Ambassador Mabandla. colleagues, we have got about 37 minutes, this allocated 2 hours. What we are going to try and do is to answer some of the questions. So if you have a question, please raise your hand. Good. Colleagues, please help us if there are questions in the chat box so that the panelists can try and respond, and other people who are here who may have questions can also do that. It is true that we need to have member states to help us because we don't have standing in the African Union. The people who can get us a resolution from the African Union are member states that seek to recall this convention and then open it up for revision. So that's one thing that we need to get, a member states or different member states that say this is what we need to do. I'm looking for hands, so people please tell me if there's a hand, whilst trying to provide more information around process. Tlamelo mentioned that the AU was in Botswana recently. We are aware that they've been to Kenya, Angola, Botswana, and Eswatini, really asking member states to domesticate. And this current state of affairs cannot be allowed to continue when we are sitting here asking to be heard and not being heard, because I think that's also part of the challenge, that we have conducted legal analysis, we have written letters to the different offices asking for one thing that we do not believe is hard. If we accept that there are challenges and also accept that there are challenges, but there are also gaps, and we understand that there were procedural flaws, the only thing that the Pose for Purpose campaign has asked is, can we be convened and enter one room and talk about what the gaps are, how they will be fixed, if they can be fixed at all, and then agree on a program of action around how we are going to do that. But at the moment, the only thing that the African Union and the African Commission on Human People's Rights have been saying is that the only conversation that's possible is a conversation about ratification, not a conversation about what's in the convention. So this is where we find ourselves, and I think we also want to hear from you on what you think we can do, because Pose for Purpose campaign is a campaign that has been around for almost a year. As soon as we got hold of the convention, read it, and saw these problems, that's when we started the advocacy, and we have not been heard. So if there are no questions,
Kabongile, there's a question from Saliso. I'm going to allow them to.
okay, please.
Yeah.
Lolo, please come in.
Thank you so much, Sibongile. Good evening, everybody, and morning or afternoon, whichever time zone you are in. My name is Loyiso Saliso, and thank you. I want to first thank the panelists for just an amazing and very rich discussion. And I think, as Ume Geraldine said, it's like a masterclass that you've taken us into. And I've been sitting with a question in the beginning of this webinar, and even when I read through the document itself, and it's on whether some of the gaps we've discussed and that are actually on the document are simply technical omissions, or whether they reflect the broader political contestation happening around women's rights in Africa. And as I listened to the panelists giving great inputs and breaking down the myths today, I couldn't help but reflect on the broader political context that we are operating in. And, we know that the anti-rights, anti-gender movements are no longer on the margins, and that they are rather deeply embedded across our continent and influencing policy debates. And the more I've been listening to this, it sounds like that's exactly what is happening. I mean, the paper itself, it does remind us that this convention was developed against a backdrop of democratic backsliding, shrinking civic space, and organized anti-rights mobilization. But also for me, coherence, because there's a part of the gaps where we spoke to coherence. And what it means to me is that asking one simple question, how does this convention actually help us implement what we have already committed to? Because we also have a habit of redoing things like we have not dealt with these issues before. And for example, if every member state right now develops separate reporting systems and accountability mechanisms and implementation plans, we obviously risk creating more bureaucracy than impact. And we don't need that right now. So for me, instead, we should build one integrated ecosystem of accountability, where this treaty reinforces the Maputo Protocol, where and the Agenda 2063, for example, and other regional commitments. And what that means is that we'll have a harmonized reporting system, shared indicators, survivor-centered monitoring, and meaningful participation of feminist and women's rights movements in tracking implementation, for instance. And lastly, I think Ruth mentioned it beautifully, that as Africa, we do not have a policy deficit. Our documents are amazing. We've put in lots of minds and brains in this. What we have is an implementation deficit, and our priority should not be around producing more commitments, but rather ensuring that the commitments we already have speak to one another, and that most importantly, translate into safer lives for women and girls, and especially for girls, so that they can live in communities and countries and even a continent where they can dream and exist without fear. So for me, that's really what I wanted to contribute to this discussion this evening. But thank you so much. And I do look forward to Saturday. Amandla.
Thank you, Lolo, for that intervention. I do not see other hands. So we have a website. May has just put it there. Please join our campaign, Pause for Purpose, www.aucevawg.org. Please come to the protest on Saturday, Galaga Estate, Midrand, at the Pan-African Parliament, 8:30. And more importantly, please ask your government representatives, your ministries of gender, departments of women, on what their position is on the convention, and ask them to convene you. Please ask UN Women and other agencies that you know have convening powers in your country, and ask that you collectively analyze this convention. If there are people who think that it is good, let's talk about it. We think there are flaws, and let's do that. So I'm just going to ask each of the panelists to take turns and wrapping up and giving us their words of wisdom on how we continue or we take this battle forward. Ruth, Tlamelo, and Ambassador Mabandla. Thank you.
Thank you so much. Thank you so much, Sibongile. For me, I think in terms of wrapping up, it would be just to emphasize that because this convention regresses the Maputo Protocol and it regresses other national and international standards, we have to really take a moment to pause and do the main thing that is important, which is to actually just analyze the convention for yourself. We have shared our own legal analysis that we did and the resources page for the campaign. But it's just, even for member states, the encouragement is really for people to read it and analyze it for themselves. Because I've found that normally when people do that, it's like immediately becomes clear that this is something that is not fit for purpose, and it's a disservice to the women and girls of the continent. And when reading it for yourself, sort of analyzing, it's just important to remember it's actually a legal instrument. So we don't read it like a political instrument, because, people have said, let's just move with it because it's a political moment. Isn't it like another recommitment to ending violence against women? We don't need another empty promise, right? We don't need another political speech about how important it is to end violence against women. We actually need tangible norms and standards. And the one thing for me, if I'm asked, right, like if we needed a convention on violence against women, what is it that it should do to close any gap that we have on the continent? My answer would be that we needed a stronger implementation mechanism on the continent. We know that we have the African Commission, but because it is overwhelmed in terms of just function, but also because of it has really problematic interpretations of the African Charter around, for example, confidentiality, it has become a mechanism that's no longer very fit for purpose, especially when you're talking about violence against women and girls. So if we were ever to strengthen what we have, and we have a convention on ending violence against women, it would be for us to have a convention that actually sets up its own implementation mechanism specific to ending violence against women. And we know this works because when we look at the Belém do Pará, if we look at the Istanbul Convention, they have unique standalone specific mechanisms to monitor states' implementation of violence against women. And we know from evidence that it works. So if we had that, I would say, okay, we have strengthened, we have closed a gap somewhere, normatively that existed. But this convention does not even do that. So I will end with that encouragement for us to read the convention for ourselves, for member states to analyze it and read it as a legal instrument, and bring that legal analysis to the way you read it. And then definitely, I am very hopeful. I am not disappointed anymore. There was a time initially when this happened where it was like very frustrating. You want to hide under the desk. It's like, how did this happen? Just like Ambassador was speaking, we have a history of really strong normative standards in Africa from the African Charter. So thank you for sharing that, Ambassador. So this one it's even out of character for the AU. This convention is out of character. So we need to correct this mistake. But thank you so much for inviting me to this space.
Thank you, Ruth. Pamela, please.
Yeah, thank you so much. I think I echo what Ruth said. Ruth said it perfectly. I think over and above that, we deserve better. And I think that we know that we can do better. And I think that our lived experiences as women and the kinds of violence we've experienced and how, accountability mechanisms just at a national level have failed us repeatedly where they shouldn't have. I really felt what Ruth was saying when she said she wanted to hide under the bed, because there are a lot of times where I've felt very, very frustrated. So I also appreciate that encouragement to say, let's keep at it. It may be hard. It may seem like it's a long, dark, winded road, but no one else is going to do it because no one else is going to stand up for our rights. We alone can stand up for our rights. So perhaps an encouragement that because of, like I said, and I keep on saying, there may be instances where, internally we have limited resources. So where we are having these discussions cross-continent, please, I don't know how we can, try, maybe keep to the Pause for Purpose website, but how else we can link into the conversations that we are having nationally so that we can also encourage maybe civil society organizations and women that want to know more, where these conversations are already happening, to log in and to try and learn more and understand more, so that we can stand united, so that we don't have an instance where we are being told things as civil society, and because we don't have the capacity and the resources to actually dig deep, that we're going with what we are being told. And that, I think, is the biggest fear at the moment, is every consultation we go to, there's one person who's turned by the, no, we can ratify and then we can just, amend later. So just an encouragement that we continue to have these conversations and continue to share the spaces that we have these conversations so we can continue to empower each other, because we really do deserve better. Thank you.
Thank you, Tlamelo. Ambassador Mabanta, over to you.
I think that you have said it yourself, Sibongile. I think we should keep at it. But then we really have to make an effort and talk to regional bodies like SADC. We need to engage NEPAD, APRM. What governance are they evaluating if in fact they are not looking at instruments and the application of commitments? by nation, by the African states. Let's keep talking. Thank you very much for everything and for everybody who have spoken. Loiso, it's true that what's happening is really part of the bigger picture. The changes, the regression is real. Yeah, no, thank you very much.
Thank you all very much for coming through tonight. Remember, all that we are saying is pause, listen, strengthen, and then ratified. We are not fighting the convention. So thank you all very much. And have
Sorry,
a
Ndashe,
one.
before you
Sorry.
leave, there's a hand there from Mamam Tokozo.
Okay. Sorry. Hi, Ndogozo, please come through.
Tokozo, you can unmute. You've been permitted to speak.
It might have been an accident. She's left.
Yeah,
Okay.
yeah, they dropped.
Thank you all very much and have a wonderful evening and take care. Thank you. Bye-bye.
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 Bye.